I'm Phillip Vondra, Chair of Beverly Hills Bar Association's Personal Injury Law Section. I am delighted to introduce our speakers, Robert Glassman and Joseph O'Hanlon. Robert Glassman is a trial attorney and partner at Panish, Shea, Ravipudi, where he represents plaintiffs in large, complex civil litigation and is widely recognized for securing landmark, multi-million dollar verdicts that have driven meaningful safety reforms in both public and private sectors. A leader of influence, thriving in their 40s through the Los Angeles Business Journal and a Daily Journal top 40 lawyer under 40, he has obtained numerous 7- and 8-figure jury verdicts as lead counsel, earning membership in the American Board of Trial Advocates. Mr. Glassman is a 3-time Consumer Attorneys of California Consumer Attorney of the Year finalist, a 2023 California Lawyer Attorney of the Year recipient, and an adjunct professor and trustee at Southwestern Law School. Joe O'Hanlon is an attorney at Panish, Shea, Ravipudi, where he focuses his practice on catastrophic personal injury and wrongful death matters throughout California. A graduate of Southwestern Law School, he distinguished himself as chair of the board of the Trial Advocacy Honors Program and earned multiple honors, including the Cali Excellence for the Future Award and the Blue Book Award. Mr. O'Hanlon is an active member of leading plaintiff side bar organizations and serves on the board of Southwestern Law School's Nickel Club, reflecting his continued commitment to advocacy, mentorship, and professional leadership. And now let's get started.
Thanks for that kind introduction, Phil. We're happy to be here. And before Joe goes ahead and gets started with the actual presentation, I just want to make a quick introductory note about kind of why we decided to do this in the first place. As practicing lawyers, we're in court a lot. We respond to pleadings a lot. We file pleadings in court. We're doing a lot with discovery. And uh, something like this presentation, talking about an evidence code section, 801.1, we weren't just sitting around in our office one day thinking, this would be a good topic to talk to folks about. This is something that came up in one of our cases, and we had to litigate this issue, and we're going to talk about that during the presentation. But, we thought after the issue became something that was important in our case, we thought it was a good idea to kind of spread the wealth and tell others about how we used it to our advantage, for our client to win the case, but also because it's kind of a relatively new part of the California Evidence Code, we thought it was a good idea to share it all with you. So that's kind of what all of these things are about. It's about education, and it's about, taking what we learned in practice and sharing it with others. You can't really get a grasp of these things in the abstract. It's not until you actually deal with it in real life in a case where you understand the importance of it. So that's just something that we think about all the time when we're working on cases. Is this a concept? Is this an issue that's worth talking about with others, with other lawyers? And that's why we decided to do this today.
Perfect. Thank you for that, Rob. Couldn't agree more. And as Rob mentioned, we are going to be exploring that case that sort of gave rise to us really understanding and appreciating this new code section. So without further ado, let's get it rolling. So as you can see by the title page here, we're going to give a presentation on Evidence Code Section 801.1, which, as we will learn, sort of levels the playing field for the admissibility of expert medical causation opinions on the plaintiff's side and on the defense side. Phillip did a great job of introducing us, and so we can just breeze right past this slide. But my name is Joe. I'm an attorney at Panish, Shea, Ravipudi, clerked at the firm during law school, graduated law school in 2024. I work for Rob, who's a partner here. So a brief agenda for this morning's presentation. We're first going to talk about the pre-evidence code section 801.1 environment. What sort of medical causation opinions were admissible on the plaintiff's side versus the defense side, and that disparity there that existed. And then we're going to give you a working definition of the evidence code section itself. As Rob mentioned, we're going to walk through a real-life case example. We'll go through some takeaways, and then, of course, we'll have time to answer any questions at the end. And then if we do have time, Robert and I are also going to walk through a little bit of tips and tricks for how to properly research opposing experts before deposing them, because this sort of falls into the same category of expert discovery. So let's get into the environment that existed before evidence code section 801.1. Plaintiffs' retained experts had to offer their medical causation opinions to a reasonable medical probability. In other words, if a plaintiff's medical expert wanted to say, for example, that a client's back pain was a result of a particular car accident, they had to stake their medical reputation on that opinion. They would have to say, based on my background, training, and experience, more likely than not, this car crash caused these symptoms. But on the defense side, before evidence code section 801.1, an expert could say, for example, well, a plaintiff's cognitive symptoms could be related to a possible learning disability that was mentioned one time in her educational records, but was never actually diagnosed, not this thing that we're here to litigate. And they essentially could testify to mere possibilities and not true medical causation. And that level of probability was often enough for the defense side to get that opinion in front of a jury. And so what was the practical effect of what really, was a double standard? I think she sort of sums it up there.
That's a great meme, Joe. Great meme.
Thank you. It's a boring topic. You got to light it up just a little bit.
Right.
Trying to keep it interesting here. So the practical effect, again, is that plaintiffs' medical experts were held to a much higher standard. But for jurors, a juror could see this double board certified doctor for the defense with this incredible CV really give what amounts to a speculative causation opinion. But because that doctor was so credentialed, really take that opinion to heart perhaps more than they should. And the rationale for this double standard was that, well, a plaintiff in a case, of course, has the burden of proof. They actually have to prove causation, whereas, of course, the defense has no such burden. And so this double standard was sort of understood for decades. It was something that was reinforced time and time again at the trial court level until 2022, when Klein versus Zimmer was published.
But let me just say something too, Joe. I mean, it should be the case that the plaintiff has the burden. We're bringing the case. It's our obligation to prove every element of our case. That's the way it should be. And obviously that's the way it was. That's the way it still is. But what was going on here was, we would put forward an expert who would give his or her opinion about causation, and rightfully that expert should be held to a standard in order to get that opinion in, and that was what's reasonably reasonable probability. That's the standard. And the defense, they shouldn't have the standard. They shouldn't have a burden because they're defending the case, they're not bringing it. And so if they were just to argue in this pre-801.1 environment, hey, look, plaintiff didn't prove their case. There's no, competent evidence that this incident caused this issue. That's totally fine. They don't need to prove anything. All they have to say is plaintiff didn't meet his burden. But it's a little bit different when the defense was saying, hey, not only did the plaintiff not prove his burden, but we actually think that this other thing that happened either before or after the subject incident is the reason why plaintiff is now experiencing the symptoms that he is. So they're going kind of beyond just the, hey, plaintiff didn't prove his case. They're saying plaintiff didn't prove their case, but there's also another reason why plaintiff is experiencing what he's experiencing. And that's the thing that, 801.1 came along and said, if you're going to do that, if you're going to put forward another hypothesis or another reason why plaintiff is experiencing what he is, then you should be held to the same standard and burden that the plaintiff's experts are too. You can't just pluck things out of thin air and say, oh, this is the reason why this is happening. There has to be some kind of, standard that the expert is held to in order to give such an opinion.
Exactly. And so this double standard persisted for quite a while, just sort of informally. There was no real case law on it until Klein versus Zimmer in 2022, which was a personal injury case. It involved a defective hip replacement. So it was a product liability personal injury case. And the trial court here sort of went against the grain, against what most trial courts were doing at the time, and actually excluded one of the defendant's experts' opinions that was not stated to a reasonable medical probability. And then the Court of Appeals remanded for a new trial. And then you can see in this quote here, they formalize that double standard. The court says the reasonable medical probability requirement applies only to the party bearing the burden of proof on the issue, which is the subject of the opinion. So it becomes law at this point. And in response, the CAOC successfully sponsored a bill which became Evidence Code Section 801.1, and it was enacted on January 1st, 2024. So here's the important part of the code section. That bolded part basically says that now even the party not bearing the burden of proof, if they want to offer some alternative causation theory, what Rob was just talking about a few minutes ago, they can't just throw it out there. They have to offer it to a reasonable medical probability, just like the plaintiff's experts do. And so what does this look like in practice? So as we mentioned at the top of this presentation, this new law came into play in a case called Hyde versus SVM Transportation. It was in late 2024 that we were about to go to trial in this case. It was a rear-ender case where an employee in the course and scope rear-ended our client in a semi-truck. And during the pendency of the case, our client was involved in a subsequent car crash and was actually hospitalized for that car crash. And of course, the defense gets the records, and then the defense's retained orthopedist really wanted to opine at his deposition that car crash following the one that we were litigating about really was the cause of our client's pain, his need for treatment, etc. And so at deposition, we asked the expert, well, can you offer that opinion to a reasonable medical probability, to the proper standard? And as you can see, the defense expert doesn't really give a straight answer. He kind of prevaricates and wants to, do his lawyer a solid, but he can't really stake his medical reputation and say, well, to a reasonable medical probability, this subsequent crash is why our client has back pain, because the records don't support it. Where in the past, you could sort of get in evidence of this subsequent crash. Now it's much more difficult.
So now's a good time to underscore this point. Joe, if you go back to that slide, anyone taking a deposition in a case involving in an injury case, and you're taking the deposition of an expert, needs to obviously ask this question. If they're giving opinions about causation, the opinion better be given to a reasonable degree of medical certainty, or reasonable degree of medical probability is another way of saying it. And if the doctor gives a equivocal answer like this one here, this is what you have to use to tee up a motion in limine to exclude that alternative causation opinion. So this for lawyers, for litigators, this question in every expert deposition that you take on every single opinion that the witness is giving about alternative causation.
Exactly. You just got to use that language, just make it a routine part of your practice.
Because it comes up a lot, in an injury case. We're all human beings. We go through a lot of stuff in life, sports, other accidents, whatever. And it's not uncommon for an expert to say, well, this person was a football player in high school and college, and they, were injured, and we have records showing that. And, there's a lot of strain on the person's back playing those sports, high contact sports, whatever it is. Even if the expert doesn't explicitly give the opinion at the deposition or writes it in his report, you still better ask the question at deposition, well, doctor, are you saying that the football injuries, or the fact that he was playing football in high school is a cause of Mr. Jones's ongoing pain and issues? And if he's like, well, it could be, well, then the follow-up question is, doctor, are you giving the opinion that his football playing and his football injuries were a cause of his injuries to a reasonable degree of medical certainty? And whether he says yes or no, if he says yes, that's sort of a gift because it's kind of a ludicrous position to take, and you could polarize the case that way. But if he says no, then move on. You got him. You're going to file a motion in limine. You're going to cite 801.1, say you can't give that opinion in court.
And you'll find that when you introduce that language, that standard to the question, doctors really will retreat off of that opinion that they maybe planned on giving, because they don't want to stake their reputation on this case or on their next case on an opinion that they probably know deep down is really actually speculative. And this new evidence code just sort of allows plaintiff lawyers to call that out a little bit and exclude on that basis.
And if anyone wants a copy of the full transcript, obviously you can email Joe or myself, and we're happy to provide it.
As well as briefing too. And we'll get into the briefing a little bit further on in the presentation, but of course we're happy to provide that too. And so this is another excerpt from the same deposition. The lawyer for the defense attempted to sort of rehab the doctor, give him another chance to offer his opinion to a reasonable medical certainty. And really all the doctor can say is, yeah, appears to be a significant accident. He's trying to throw the lawyer for the defense a bone here, but he really can't offer his opinion to that standard because the records just don't support it.
We got a question asking, I think what we just kind of brushed on is the depo question used certainty instead of probability. Was that an issue? I mean, that's a good question. I think that, the case law, obviously, in the 801.1, the statute says probability. It doesn't say certainty. I think that lawyers get in the habit of using both interchangeably, and they think it's synonymous. Certainty sounds a little bit more scary. Can you give that with absolute or, reasonable certainty? It didn't come up in this case. I can foresee it being an issue if the opposing counsel wants to nitpick and say, hey, look, that's not the standard. The standard's probability. I do think it is a I do think it's a better practice to use to track the language of the statute, which is probability. What do you think, Joe?
I agree. As you said, Rob, in this case, it didn't come up. And obviously, the word certainty maybe sounds a little bit more scary than probability, but really it's about, reasonable, taking into account their medical background. And so I think that may be why it wasn't an issue in this case, in dealing with this opinion. And just sort of going forward, for whatever reason, I'm not seeing the questions as they come up. So Rob, please, if you see a question that you want to address and I'm not doing that, it's because I can't see. So feel free to just jump in.
Yeah.
And so the defense lawyer, again, tries to rehabilitate his witness, not able to do it. And so we moved to exclude any evidence of this subsequent car crash that our client was involved in. And the basis for that motion was this doctor can't offer his alternative causation opinion to a reasonable degree of, in this case, medical certainty, but medical probability. And therefore, any evidence of this subsequent crash is completely irrelevant to the issues in the case. It has nothing to do with liability or his damages. And on that basis, the court kind of said, not so fast on that opinion.
Another great meme.
Yeah. Is that Dikembe Mutombo? I'm trying to figure out who that is. If someone knows, please put it in the chat. I've been trying to figure it out. It's a little blurry, so it's tough to tell. And here's the minute order from the judge excluding any evidence at all of that collision, which is obviously, it's really, really valuable on a lot of fronts. Number one, it nips any alternative causation in the bud. The only thing that could have caused our client's injuries now is this crash that we're all here to talk about. And you never want the jury to hear about your client being in some other car crash when you're there to talk about a case where he's involved in a different car crash. It just makes your case a little messier, maybe makes your plaintiff a little less sympathetic. And so it was a really, really strong result for us. And I think it helped the case resolve right before trial. And so
and you can't assume that the judge is gonna always be up to speed on new developments in the law. Know that 801.1 exists. You can't assume that. I would say even if an issue doesn't come up during expert depositions on this issue, it's probably a good idea to just do a pocket brief on 801.1 in case an expert starts to talk about alternative causation opinions in court. I mean, you run into a Kennemer issue perhaps too, which is you can't articulate an opinion in court that you didn't in your deposition, but it might just be a good pocket brief to file with the court leading up to your trial as well, just to educate her about the new law. We do that a lot. I mean, just pocket briefs on a lot of different issues just to make sure the judge is up to speed on the issues in case something comes up during the trial.
So as Rob was just saying, some basic practice tips here we've covered using that 801.1 language at deposition. And as Rob said, it's really, really important to educate the judge in briefing on sort of where this bill comes from, how it came about, when it was enacted, et cetera, because, it's been around since January of 2024. It's still pretty new. And, there are judges who have been on the bench for decades who have probably been ruling on these issues a certain way for, most of their careers. And so it's extremely important as Rob mentioned, to be very thorough in your briefing. And, I think a pocket brief's a great idea. That's something that we do quite a bit in our cases that are about to go to trial. It's a great way to sort of tee off a discussion on an issue that we think is going to be important during the trial. And this would be a great candidate for something like that. And on the defense side, it's extremely important to understand this new standard as well, because, it should, if you're a defense lawyer, affect your evaluation of a case. Whereas 3 years ago, you may be able to introduce some potential alternative causations that may devalue a case. That may not be so anymore. And so you need to take that into account when you're preparing a case for trial, taking stock of what opinions or experts are going to be able to render at depo and to testify to in front of a jury. So it's a really, really important new law for both sides of the personal injury bar to take note of.
We have a couple more questions before we get to the next slide, Joe. So first one is, why couldn't the subsequent accident be presented to the plaintiff's expert to inquire whether they can exclude the subsequent accident as a contributing factor to a reasonable medical probability? And I think that's a good approach to take, and you can. In this particular case, because the plaintiff's expert had already considered that possibility and testified at deposition that the subsequent accident was not, to a reasonable degree of medical probability, a factor in his ongoing issues. And the defense expert likewise couldn't articulate that opinion. The judge ruled on the motion in limine to exclude it altogether. So you couldn't even bring up the fact of the subsequent accident with plaintiff's expert, because that issue was in fact presented to plaintiff's expert during expert depositions, and he testified that it was not. So, but I think that's a good idea that, if you have an opposing expert, who's giving alternative causation opinions, you should then pose those opinions and really hypotheticals to your own expert to comment on during their deposition, so that you don't run into an issue at the trial, right? So, I think that's a really good thing to do, to clean up at the end of the deposition of your own expert. After the other lawyer's done, you can then say, hey, look, doctor, the other doctor in this case who was hired by the defense, they're saying this. They're saying that there was a subsequent accident, and that accident was the reason why the plaintiff needed the surgery, or that subsequent accident is the reason why the plaintiff is still in pain. Do you have an opinion on that? And get your expert's opinions out at the deposition, so that you can then show the judge, hey, judge, look, not only does the defense expert opinion say that the subsequent accident's not an ongoing factor, but the plaintiff's expert also says that it's not, he can't give that opinion to a reasonable degree of medical probability. So you should address it with your own expert too. I think that's a good question and a good point. That way you're covering all your bases. There's another question. Joe, do you have anything to say about that?
No, let's go ahead with the other question.
The other question is, how do you define medical probability, like to a jury, to a retained expert, to a deponent? And that's a good question too. To me, it's sort of like the standard that we're held to in court to prove our case. We have to prove our case by preponderance of the evidence, and we always define what that means to the jury to help them better understand what we need to do in order to prove our case. And I think that they're pretty synonymous. I mean, A reasonable degree of medical probability to me is it more likely than not? You know, is the opinion backed by a 50.1% probability, just a little bit more than um, half? I think that's what it really means. Is it more likely than not? Is it just a little bit more than 50%? And if it is, then it can come in, and that's the standard. Just like that's our standard to prove our case. That's our burden of proof. So I think that would be the way to articulate it in court to a jury.
Right. When you strip it all down, it really just means more likely than not. And, again, that's significant because before this evidence code section existed, that really wasn't the standard for experts on the defense side. They could testify, well, this person's symptoms could have been X or it could have been Y. And so the new standard for everyone is just more likely than not, just like it is for the plaintiff to prove the rest of their case. Any more questions, Rob?
Not right now.
Okay. So just some takeaways here to round things off on this topic. Again, 801.1 is an essential tool for plaintiffs' lawyers. You need to be using it at deposition. You need to be educating your judge on exactly what the law means, its history, why it was enacted. Defense lawyers, of course, need to incorporate this new standard for their experts into their practice as well. And really, it clarifies the landscape for both sides, because before, there was no appellate or statutory law on that disparity in the medical causation standard. And so you would see sort of broadly consistent results on what defense expert opinions were admissible. But of course, it varies from judge to judge. And so this statute, this new evidence code, introduces some clarity for both sides, which I think hopefully will drive more resolutions before trial, allow sides to evaluate their cases more consistently and with more confidence. And, I think my personal biggest takeaway, and Rob, when I'm done here, I'd love to hear if you have any takeaways, but personally, my biggest takeaway, just from the whole story of this evidence code and how it came about, is that it's a really important reminder for lawyers, on both sides of the personal injury bar in any area of practice, to support those advocacy organizations like the CAOC, for example, who sponsored the bill that became this evidence code. It's important to support those advocacy organizations who you feel are doing the work that is going to secure the long-term future of your practice and make a difference for your clients. Because that really was, how this evidence code came to be, is that the plaintiff's bar saw what they thought was an issue here with this standard, and then they took action to change it and were successful in doing so.
Yeah, and actually, so there is another question, and it's a good one too. Is there case law agreeing with the 51% standard for reasonable medical probability? Great question. And what I've been able to track down is that actually in the legislative history for the law, it was Senate Bill 652. And I think this is something that you can cite to in your briefing if it ever comes up, if you ever get pushback, that reasonable medical probability is in fact 51% or more likely than not. You can cite to this legislative history from the actual Senate bill that ended up being, 801.1, but it's Senate Bill 652, and it says that basically the new provision to hold all experts to this standard must be made to a reasonable medical probability, meaning the injury, quote, was more likely than not, end quote, a result of the alternative cause. So that's in the legislative history behind the law. Um, it also says that in the legislative history, the law heightens the bar to which experts will be held to ensure this particularly impactful testimony is reliable and not misleading. So again, if you ever get pushback on what does it actually mean, you can cite to the legislative history. And when it gives you that more likely than not language, that's the language obviously that tracks the KC jury instruction on plaintiff's burden of proof on the preponderance of the evidence. The jury's told this means more likely than not.
And the policy rationale there that's described in the legislative text, really sort of aligns with what we were talking about earlier. This expert testimony, when you hear an opinion from, again, a doctor with an incredible CV who has all these impressive accolades, that is, as they put it in SB 652, very impactful testimony. And so you want that opinion to be rendered to a reliable degree of certainty. And so, yeah, that would be great material for a brief, as Rob said, if you do get some pushback and you need to really explain to the judge why it's important that we adhere to this new standard.
Yeah.
Any other questions from anybody?
Let's see. If the focus of the defense opinion was that the second accident was a contributing factor as opposed to the sole cause, how do you think that plays out?
Well, in this case, maybe I should have been a little more clear. That was the defense expert's opinion that he hoped to offer, was that this subsequent accident was contributing to his symptoms, not that it was the sole cause. And so we actually saw that scenario play out in this case, and the judge was able to, the judge chose to exclude it.
Yeah, it doesn't matter if the alternative causation opinion is this is just one factor in contributing to the injury or the sole factor. If it's an alternative causation at all, it has to be given to a reasonable degree of medical probability. It doesn't matter if the doctor is saying this is the only reason why plaintiff is having these issues or this is just part of it. I agree that the subject incident is a cause, but I also think that this subsequent accident is another cause. If you're going to give that alternative causation opinion, even if it's just part of it, it has to be given to the reasonable degree of medical probability standard.
And from what we've seen, that's typically almost always how this plays out. It's not a defense expert trying to pin every single one of a plaintiff's symptoms on some, for example, subsequent accident. They say, well, this was probably part of the equation. So that's almost always what it looks like.
Yes. And again, we'll send the transcript of this particular expert and the motion in limine itself that we filed to exclude that alternative causation opinion.
Okay, well, if we don't have any more questions on this topic, Rob and I were going to spend the next few minutes diving into, since it is sort of in the same realm, a few tips and tricks for how to quickly and effectively research opposing experts before you take that depo. So I'll go ahead and stop sharing my screen for a second to get a piece of that presentation up. And we just thought it made sense to include this in today's presentation because, again, this is all under the realm of expert opinions, making sure you maximize the impact on that expert depo, score as many points as you possibly can, position your case for trial as advantageously as you possibly can during that expert discovery stage. And so we put together this presentation as well to give you a quick little checklist to run through as you're getting familiar with an opposing expert before deposing them. And I tried to throw a couple cool memes and GIFs in here too, so we'll see if those land.
Right. Joe, before you go on to that, I kind of want to go back to just again this how do you articulate the burden or the standard in court? Because I think it's a good question. And you know, if everyone looks at KC 200 in the jury instructions, it's called obligation to prove, more likely true than not true. And that Casey applies to not just the plaintiff, but to the defense as well. The text of the actual jury instruction says the parties must persuade you. The parties must persuade you, not the plaintiff. The parties must persuade you by the evidence presented in court that what they are required to prove is more likely to be true than not true. This is referred to as the burden of proof. So when the defense has an alternative causation argument to make, or when their expert has an alternative causation opinion to give, under 801.1, they have to give it to a reasonable degree of medical probability. But because now it's their basically affirmative defense, they now bear the burden of proving that. You go back to KC 200 that says, all right, you're trying to prove something to us in court. We know you have to prove it. You have to, in order for it to even be articulated, in order for you to even give it in court, you have to get past the threshold standard, which is reasonable degree of medical probability. But now, in order for the jury to believe in it and agree that you've proven that, it's more likely than not true. So I think you use the KC 200 and 801.1 in conjunction. If you're ever confronted with an issue of, well, what does 801.1 really mean? What does the standard really mean? And I think that using 200, KC 200 as a complement to that will help the judge and help the jury understand.
Perfect. Thanks for that, Rob. So just briefly diving in here to this expert research topic for the next few minutes. Westlaw is a great tool to learn about an expert's testimonial history, whether they've been excluded, which obviously is extremely valuable to know. If you can get evidence in front of a jury that the opposing expert has been excluded from testifying before and your expert hasn't, that immediately puts your expert ahead in that credibility battle. And so, again, this is low-hanging fruit, luckily, because it's quick and easy to do on Westlaw. And also, a quick internet search can never hurt either. And we're going to walk through exactly why sometimes that can give you a big benefit. So we'll use a real-life example to illustrate sort of how useful Westlaw and a simple Google search can be. This was a case that Robert and our colleague Nadine, who also works here at Panish, Shea, Ravipudi, had against Target. It was a premises liability case, and they had this corporate security expert who was sort of their main liability expert. He's a consultant, and he also does expert work. And so we sat down to research him. And the way that you can sort of find those prior exclusions, his testimony history, etc., is if you just go to the Westlaw homepage and you hit expert materials. And you'll see from there, you can take a look at their depositions, for example, search the person's name in the field. And then there's this treasure trove of prior testimony that you can look through to see whether, any opinions that he's rendering in these previous cases maybe conflict with what he's offering in your case. Again, all about trying to find ways to call into question their credibility when they testify.
We talked about standard of care as litigators. I mean, earlier about, you have to ask that question at every single expert deposition of a medical expert. Are you giving this opinion to a reasonable degree of medical probability? That's standard of care. So is this. Doing this kind of Westlaw research on an expert who you're about to depose, you owe it to your client to do this. You owe it to your case and to your cause to do this because, I mean, this really gives you the ammunition to dismantle, really, oftentimes the expert's qualifications and opinions in a case. So I know, we get busy and there's a lot of stuff that we do as we're gearing up for trial, but these types of doing this type of research and these types of exercises is really it proves very, very beneficial in the case.
Absolutely. And just going back here, you can see you can find prior expert reports as well, reports they've authored or affidavits they've signed maybe in support of an MSJ, et cetera. And, maybe a more recent example, Robert and I had a trial last year where it involved an auto collision, involved a speeding police officer who was going 80 miles an hour in a 35. And they had this liability accident reconstruction expert who basically tried to opine in our case that the officer's excessive speed actually wasn't that dangerous and it wasn't really a huge contributing factor. And Frank, essentially, it wasn't a huge deal that he was going more than double the speed limit on this surface street. And we found a report in Westlaw where he says the exact opposite thing. He actually cites a study that provided that, for every mile an hour you go over the speed limit, it increases your chance of being in a collision by this much. This scientific study that directly refutes what he's opining in our case that he cited in some other case previously. And so it really, really undercut his credibility, because at that point, if you're a juror, how are you going to believe anything else this guy has to say? And again, that took probably a half an hour research on Westlaw. It's something that we do before every single trial for every single expert, is we sort of dive in and see what we can find. And so in this case, Mr. Grossman, back to the Target case example, he's their premises liability expert. We found out that he'd been excluded back in 2018. And then you can actually get the exclusion itself. And so that's obviously, a pretty good moment. That's something that is really material to the outcome of your case. And then what's cool is you can actually get the order itself, the exclusion order that lays out, yes, this defense expert is being excluded from testifying at trial, which again, really, really hurts their credibility. This is now an exhibit at depo, and you can get them to sort of face the music on it.
We can't hear the sound.
Uh-oh. See if I can figure this out.
Meanwhile, there's a question. Do you start Westlaw search with your own experts? Yeah.
Yeah, absolutely.
Not just with our experts, but we will do investigation into our clients, into percipient witnesses who we want to use at trial. You have to make sure you got to do that too. I mean, because of course you're asking your clients and you're asking family members or friends of your client, hey, is there anything we need to know before you get up there and testify? Any criminal issues, any restraining orders, anything at all. And, sometimes they may, even though they're trying to be honest, they may just not remember, or they don't think that what happened to them 10, 15 years ago is important, and it may not be important until they get caught in a lie about it. And then all of a sudden it's now important. And that's what we always tell our clients too. It's, hey, this, if you got arrested for a DUI, and for whatever reason, if that issue's, relevant in our case, or if we let them answer that question, um, they better answer it truthfully. Because if they answer it truthfully and they say, yes, I was arrested for DUI, we're going to file a motion in limine to exclude that. And because it's just not relevant, and let's just say it's very remote in time, the judge is going to grant that motion, and it's not going to be an issue. But if they say, no, I've never been arrested for a DUI, but in fact they were, now all of a sudden they're putting their credibility at issue, and that is relevant. Their credibility is always relevant. And so don't make a non-issue become an issue, um, uh, in these cases. And so that's why, to get back to the question, yes, we do research on our own experts. We do uh, research on our own clients. Really, you're doing it so you can get ahead of the issue. If you got a problem with your expert, if it's really bad, maybe you should consider not using them. But if it's, not terrible, but it's still an issue, just get ahead of the issue. Shape the narrative on it. You extract it on direct before the defense can expose it on cross.
Exactly. I mean, coincidentally, 2 days ago, we just retained an expert in a really tragic school drowning case, and it was an expert we never worked with before. And so before I got on the phone with her, I looked her up on Westlaw, gave her a quick Google, and just made sure that she didn't have any, skeletons that were going to hurt us down the line. So, I think maybe I got the sound to work, but if not, it's fine. We'll just move on.
And Mark, as Exhibit 2,
Do you guys hear that?
Yes.
just another document here I'll show you. This appears to be an order in a case in Texas from 2018 in which the judge ordered that you're going to be excluded from testifying in this case. Do you remember this as well?
I do remember that. Yes, it was a shooting outside in the parking lot of an adult entertainment club.
So just for the sake of time, I'll move on. But he doesn't really have anything that he can say to sort of rehabilitate himself after that. And another step here is just do a quick Google, do sort of a Google, mini deep dive on this person to see if there's anything out there that may suggest some sort of bias. Because a lot of these people that have, extensive histories as expert witnesses, they're going to have something out there that is relevant to your case in many instances that may not be the best for them when it comes to, again, the facts of your case. And so in this Target case, one of these articles that Mr. Glassman wrote, sort of to market himself, it seemed like, kind of bit him in the end. So he writes here in this article, never admit that you or your company acted negligently or recklessly. And he's sort of, and the title of the article is not great for me either. Pre and post incident actions to rebuff negligent security lawsuits. So right off the bat, it's very clear to everybody, this guy's completely in the bag for the defense. He's biased. And so it's not easy to take what he says seriously. Which, becomes a problem for him when he's trying to come into this case as this objective expert who's here merely to offer his unbiased opinion on the facts.
I mean, yeah, if you got this expert wrote down on an article that he, puts out to the world that in these types of cases, you should never admit that you or your company acted negligently or recklessly. I mean, at that point, there's nothing they can do to unring the bell. And, the jury is going to think, no matter what he says, that he's biased, like Joe said. I mean, it is such a unequivocal statement that, you just never should do this. So before he even heard the facts of this case, that's his opinion. I mean, he just never admit that the company did anything wrong. So it doesn't matter if they in this case, actually, in fact, did do something wrong, you're going to still say that they they didn't, and that you're advising them that they shouldn't ever admit that, and you're going to tell us yourself that they weren't. So there's really no coming back from such a unequivocal statement like that.
Did we get a question, or am I?
No.
Okay. Well, I don't know what I'm seeing then. And of course, Rob brought this up to Mr. Grossman during his depo.
At this presentation, which is also encompassed here in this republication, is never to admit that you or your company acted negligently, correct?
Yeah, that's one of the tips that we gave, mainly talked about by one of the attorneys that was on the panel. There were two attorneys on the panel. Negligence is, I don't need to tell you, can be a legal term. And so what we were trying to express to the attendees, who were asset protection folks from many different companies, was, what you may think as negligent may not be the same thing that a lawyer thinks or that a court thinks. So it's being careful with words.
Okay. And you also said in this presentation, never to admit that you or your company acted recklessly, correct?
And again, for the same reason, so that there's not a misinterpretation between what a layman would think of in terms of reckless versus a court or a lawyer potentially.
And he can try and clean it up with, all that backtracking there in his answer. But as Rob said, the damage is done. I mean, he wrote down, never admit basically that you did anything wrong. And so the clear impression there is that this guy came into this case and already had his opinion formed before he even heard the facts, which is all the jury needs to know in deciding whether or not they should, believe this guy.
At this presentation, which is also encompassed.
It's like it might be the same slide. Any questions on this topic?
It doesn't look like on this topic. We have a long question. Let me read it from RJ. All right, going back to 801.1. And Joe, I think you could take down that slide now.
Yeah, thanks.
But going back to 801.1, what about emotional distress damages in an employment case? In those cases, there's an issue of whether there's evidence of emotional distress, and then there's the question of what caused it. And unlike an accident, which usually is not disputed occurred, whether a person was harassed is often in dispute, and the psych expert has no ability to say what happened or not. Is there an argument? Would 801.1 preclude a psych expert from opining that certain emotional distress was caused by harassment if that expert acknowledges that they do not know that harassment occurred? I mean, look, 801.1 is in the evidence code. It's not a personal injury statute. It's all evidence. And in Joe, can you put up 801.1 again, the actual language of the statute?
Sure.
RJ, I think that that expert in that particular scenario is subject to the same standard that any expert would be giving about an alternative causation. Whether it's an employment case and they're saying, well, if the opposing expert's saying, hey, look, this person's experiencing emotional distress, or if they are experiencing emotional distress, it's not from harassment at work. Okay, sir. So what is it from? Well, I don't know. Well, okay. So that expert that opinion might be precluded because it lacks foundation and it's speculative, because an expert can't give an opinion that's speculative or lacks foundation. But if that expert were to say, well, this person is dealing with what they are with all this distress, not because of the harassment, but because they have marital problems with their spouse, then that would be subject to 801.1, because distress and emotional distress from being talked about by a psych. I mean, that is a medical issue, and that's a medical causation issue. So if they can say that the distress is being caused by, um, you know, disagreements or a bad relationship with their spouse instead of the harassment that they experienced at work, they need to be able to say that to a reasonable degree of medical probability under 801.1. So I think it would apply equally in an employment case in that kind of context as well. Especially if it's a psych. If it's the psych who's giving that opinion, that's a medical expert. So medical experts are subject to 801.1, whether it's an employment case or a physical injury PI case.
So I was going to say, yeah, I mean, the psych is a medical expert. Okay, I finally caught up to where we see the questions, and it looks like only took me an hour. It looks like we don't have any more, and we are past time. So unless anybody has any last second questions, then we'll close things up and say thank you to everyone for coming. Really appreciate it.
Yeah, thank you, everyone. And again, I mean, in order to effectively cross-examine these experts at their depositions or trial, you just need to know what's out there. And 801.1 is something that you need to know. And the Westlaw research that we showed you is also a very effective tool in learning about your opposing experts' weaknesses and soft spots. So, everyone's capable of doing this. You just need to know where to look and what's out there. So, hope this was beneficial to everyone. And again, if anyone has any follow-up questions or wants examples, please email or call Joe or myself. Thanks so much.
Yeah, thank you everyone so much. Really appreciate it.